Hello and welcome to the 17th episode of Wahl on Law. My name is Jonas Wahl, and I am a pre-law student at the University of Delaware. On this podcast, we cover what's happening across the country in law and policy and how it affects your daily life. Today, we're joined by a special guest, Ilya Somin, who is a professor of law at George Mason University, to break down the impact of President Donald Trump's tariffs and the limits of presidential power. Professor, thank you so much for coming on the podcast today.
Thank you for having me.
To start, it is my understanding that you were involved in litigation challenging President Trump's tariffs. Could you explain your role in that case and what your work focused on?
Sure. So the case challenging Trump's tariffs under the International Emergency Economic Powers Act of 1977 actually originated in a blog post that I wrote in February of last year, where I outlined some potential arguments against it. I was then approached by Jeff Schwab, a senior lawyer for the Liberty Justice Center, which is a public interest law firm. He said he'd be interested in bringing this case. So when Trump further expanded those tariffs, I wrote a follow-up blog post after consulting with Jeff and others, seeking potential clients for the case. We were able to recruit a number of small businesses that wanted to be part of it. And then we challenged the tariffs in court. And I, along with lawyers for the Liberty Justice Center, and later on others who joined us, like Michael McConnell and Neil Katyal, two prominent Supreme Court litigators. I was part of the legal team all the way through. We won in the Court of International Trade. We then won in the appellate court, the Federal Circuit, and finally in the Supreme Court.
And before we dive deeper, I want to define one term for my listeners. What exactly is a tariff?
Sure. A tariff is basically a tax on imports. So, for instance, as part of the so-called Liberation Day tariffs that Trump was challenging, that we were challenging, that Trump imposed, and that we were challenging, he imposed 10% tariffs, which are essentially 10% taxes on almost all imports from around the world, plus a lot of additional taxes on other imports.
And what industries did Trump's tariffs impact, or was it really just all industries?
So it impacted a vast range of industries all around the country, probably almost all industries in one way or another, because even industries that don't directly import goods from abroad, they often depend on imported goods. So, for instance, almost everything you make in terms of things like cars, houses and so forth depends on imports of steel and aluminum and other kinds of raw materials. And so when the cost of those goes up, the cost of the products made for them also goes up, and it affects consumers and industries, even those that don't directly import themselves.
So at that point in 2025, the tariffs were already having real economic effects. But the bigger question isn't just what they did, but it's whether the president had the authority to impose them in the first place. So I want to first get into the justification behind these tariffs. I understand that the Constitution assigns the power to impose tariffs to Congress. So how does the president also have that power?
He doesn't really. At most, he might have the power to impose tariffs in some cases where Congress specifically delegates him that authority. And even then, there are constitutional limits on how much of their power they can give away.
And the president sometimes has multiple pathways to impose tariffs, even if that power isn't implicitly given to the president. But here, President Trump chose to use the International Emergency Economic Powers Act, or IEEPA. Could you explain what this act is and why it was the tool that President Trump used in this case?
So this is a law enacted in 1977, which gives the president certain kinds of powers to deal with national emergencies that arise from, quote, an unusual and extraordinary threat emanating from abroad to the U.S. economy, national security, or foreign policy. The law doesn't even mention tariffs or any synonym for tariffs at all, but it does, among the powers granted in those kinds of emergency situations, create an authority to, quote, regulate importation of goods. And Trump claimed that power to regulate importation included a power to impose tariffs, and moreover that he could then impose those tariffs pretty much any time he wanted in any amount for any reason. I think the reason why the administration was attracted to this statute, even though it was a really terrible argument that they made, is that if the argument had worked, they really would have virtually unlimited tariff authority, whereas other statutes delegating tariff authority are much more limited. If it's true that regulate importation includes the power to impose tariffs, and also that an unusual and extraordinary threat is just whatever the president says that it is, and that's really the position that they took, and that the president can declare an emergency anytime he feels like it, then this would have been essentially a blank check, and obviously they were attracted to the idea of having a blank check.
So President Trump kind of interpreted it very broadly in maybe ways that wasn't intended to be interpreted. And then in April of 2025, companies filed a major lawsuit against President Trump and argued that IEEPA does not authorize the president to impose tariffs. So what was the core legal argument behind their case?
We made a number of different arguments, but I think essentially three of them were the most important. One is simply that this law doesn't authorize tariffs at all because the power to regulate is not the same as the power to impose taxes. Second, we noted that even if it does authorize some tariffs, it could not authorize these tariffs because the official rationale for the tariffs for most of them was trade deficits. Trade deficits are not unusual or extraordinary or even a threat at all, and therefore they don't fall within the statute. Then we pointed out that if this statute could be interpreted to give Trump this broad power, if there's some doubt about it, the major questions doctrine comes into play. This is the rule of interpretation, which says that when the executive claims that Congress has delegated to him some vast sweeping power over a major social or economic issue, he at least has to show that Congress clearly did that in the statute. And here, there's no way that it was actually clear, and it's very obvious that this is a major question because this started the biggest trade war since the Great Depression. If allowed to stay in place, would have had massive economic effects. So this is a major question, if anything is. And then finally, we noted that if you can somehow overcome the major questions issue and the other issue, and you conclude that IEEPA did grant the president this power, it would be unconstitutional because the Supreme Court has long held that there are at least some limits to Congress's powers to delegate its authority to the president. And if there are any limits at all, then certainly it would be unconstitutional for Congress to essentially give a complete and total delegation of his tariff authority to the president that would allow him to impose any tariffs he wants on any nation for any reason in any amount at any time. So those were the main arguments that we made. That there are some other more technical points that also came into the case.
And those are three really strong arguments. And in February of this year, the Supreme Court ruled 6-3 that these tariffs were unlawful. But there were still 3 justices who dissented and went against the majority opinion. Why did they dissent, and why did they believe that the tariffs should be upheld?
Yeah, so I think they bought some bad arguments. One is they claimed that the word regulate includes the power to impose tariffs because tariffs have regulatory effects. That is, they can increase or decrease the amount of imports that come in. That's true, but by that standard, that would mean that anytime Congress creates a statute which gives a power to regulate, that would also be a power to impose taxes, and that just isn't true. And if it was true, it would have radical sweeping implications for all of law. In both the Constitution and in the history of federal statutes, the powers of regulation and taxation are separate and distinct, even though no one doubts that taxes can have regulatory effects. But the fact that something can have a regulatory effect does not mean that it is a regulation. Second, Justice Kavanaugh in his dissent argued that major questions in non-delegation don't apply to so-called foreign affairs powers. And there are many problems with that argument. Among other things, the Constitution nowhere distinguishes between foreign affairs and domestic powers. It distinguishes between powers granted to Congress, which are in Article 1, and powers of the executive in Article 2. In addition, even if you accept this foreign versus domestic framework, it is very clear that tariffs are not a purely or even primarily a foreign affairs power because they are taxes imposed on Americans. And all economic studies show that over 90% of the burden of these tariffs were actually borne by American businesses and consumers. It's true, obviously, that there is a foreign policy effect too, and there's a negative effect on our trading partners as well. And the tariffs also screw up our relationships with allies. But many domestic policies have some effects on foreign affairs, policies on taxation, investment, regulation, and so forth. Have such effects, but that did not prevent the Supreme Court from saying that such policies come under the major questions doctrine. For example, the Supreme Court ruled that efforts to regulate global warming qualify as a major question and overturned, therefore, some proposals that the Biden administration had. No one doubts that global warming is a international issue with such effects. Similarly, the Supreme Court rightly, I think, ruled that the eviction moratorium imposed during COVID by Trump and then later by Biden was a major question, even though part of the purpose of the eviction moratorium was to limit the spread of COVID coming in from abroad into the United States, as well as limit it within. And I can give more examples like this, but that argument just isn't supported by logic or by Supreme Court precedent. And then there's a somewhat idiosyncratic dissent by Justice Thomas, which only he joined, and we can go into that if you want. But if that were to be adopted by the court, which fortunately there's no sign that it would be both seriously wrong-headed and would have very dangerous implications because it would give Congress the power to completely transfer almost all of its authority to the president, except perhaps in a few select areas. And nothing like that is in the text or original meaning of the Constitution. And if you're a living constitutionalist, it would have terribly dangerous effects. So you would have reason to oppose it as well.
That was a perfect explanation. And it seems like the core of this really is separation of powers, making sure that the president doesn't have too much authority. Is that basically the main issue at stake?
Yeah, essentially, the framers of the Constitution deliberately set up a system of separation of powers so that not all powers would be concentrated in the hands of any one person or even any one group of people. And in particular, they were very concerned about the executive being able to impose taxes. Tariffs are a form of taxes on his own without legislative authorization. This is actually one of the issues that led to the English Civil War, because King Charles I tried to impose taxes without the consent of Parliament. He literally lost his head eventually in part over this issue. And what he did actually bears striking similarities to what Trump tried to do in that Parliament had previously authorized so-called ship money taxes to be imposed on coastal communities in the event of invasion in order to build warships to try to resist invasion. And this was supposed to be only used when there's an actual threat of invasion, only in coastal communities. King Charles basically said, we can impose this on interior communities too, and I can do this whenever I want because everyone has to defer to me if I say there's an invasion risk. That should be enough. And this is more or less the same sort of thing that that Trump tried to do, except that he went even further because at least the ship money laws did authorize taxes, at least to some extent, whereas IEPA didn't authorize them at all. But like King Charles, Trump also claimed that he was the sole judge of when there is an emergency or an extraordinary and unusual threat, and therefore that he could impose these taxes anytime he wanted to. And the framers of the Constitution learned from the example of King Charles I and other British monarchs, and they didn't want to repeat the same sorts of problems here, which is why they were very careful to ensure that revenue-raising powers are solely held by Congress and not by the executive.
Perfect. And one would think that after the Supreme Court struck down these tariffs that, argument over, no more tariffs. But in response to the court's ruling, the administration didn't step back, it actually pivoted. So in February of this year, President Trump imposed a new 10% global tariff under Section 122 of the Trade Act of 1974. How does Section 122 differ from IEEPA in terms of legal authority and limitations?
So I would note that these tariffs are also illegal, and that's actually what the Court of International Trade ruled just yesterday. In a decision on this subject, you can read my post about it at the Vola Conspiracy blog hosted by Reason Magazine. I wrote about it yesterday. I'm not one of the lawyers in that case, but I did write an amicus brief, a friend of the court brief, on behalf of myself and the Cato Institute, which is a leading think tank. To explain the Section 122 thing, we have to take a little excursion into the history of the international monetary system. Section 122 does, unlike LIEPA, Section 122 does authorize tariffs, but only in limited circumstances, specifically when there is a serious international balance of payments problems, which result in large and serious balance of payments deficits for the United States. In that circumstance, the president can impose tariffs of up to 15% for up to 150 days. But what they mean by balance of payments deficits and problems is something that was specific to the fixed exchange rate system that existed prior to 1973, but does not exist anymore. Specifically under that system known as the Bretton Woods system, the United States committed to exchanging dollars for gold at a set rate of $35 per ounce of gold, and other countries committed to exchanging their currency for US dollars at a fixed rate. So in that system, you could have, and sometimes in the 60s and early 70s, you did have situations where US government gold reserves were running down because there was too much of a demand to exchange dollars for gold. And so you could have a balance of payments problem there. In addition, there could be problems with exchanging dollars for other currencies at fixed rate because there could be a run on the dollar or a run on those other currencies. This provision, Section 122, was intended to deal with that. The Bretton Woods system had already collapsed by the time this law was enacted in 1974. That system collapsed in 1973, but there was a lot of uncertainty, and there were negotiations going on between the U.S. and other countries to potentially reinstate some version of the fixed exchange rate system. In the end, beginning with the Jamaica Agreement of 1976, the U.S. and the other leading Western nations all agreed that they were not going to go back to the fixed exchange rate system, that they would be on a flexible exchange rate system, and therefore the kinds of balance of payments deficits that Section 122 was meant to address simply cannot arise under the flexible exchange rate system we have today because the U.S. government isn't committed to exchanging gold for dollars, and if there's an increase in demand for dollars, then simply the value of the dollar on exchange markets would simply go up. And that is why Section 122 has never actually been used to impose tariffs until now, because it sort of applies only to this situation that doesn't actually exist. And that's more or less what the court ruled yesterday, though it also relied on non-delegation arguments as well. We made a non-delegation argument in our amicus brief, and we pointed out there that if the court were to accept the Trump administration's position in this case, which is that the president basically gets to define what counts as a balance of payment deficit, then he could use Section 122 to impose massive tariffs on pretty much any time he wanted to, and that would be a breach of non-delegation, and it would be limited to 15%, but 15% is extremely high, and by itself would still be the highest tariff schedule we have had since the Great Depression, with the possible exception of the IEEPA tariffs that the Supreme Court just struck down.
So I want to shift to the real-world impact of these tariffs, as there was quite a lot. It's estimated that around $166 billion was collected under Trump's IEEPA tariffs. What happens to that money? Is it refunded? And if the money is refunded, who does it go to?
So this issue got remanded by the Supreme Court to the lower courts, and the Court of International Trade decided, I think absolutely correctly, that all the money does have to be refunded. And Judge Eaton of the Court of International Trade issued an order saying that all the money has to be paid back to all of the companies from which it was collected, even those that didn't file specific lawsuits seeking refunds. The CBP, the government agency that collects the tariffs, as a result of the court order, has set up a system in which companies can file for tariff refunds. That system, as I understand it, became operational, I think, on April 20th, and refunds have begun, but the system is complicated and bureaucratic, and smaller firms with less resources and legal sophistication may have some trouble in using it. And in addition, while it's totally necessary and just and legally required that the money be repaid to the people who paid it, including my former clients, this will not actually fix all the damage caused by the tariffs, because a lot of that damage is higher prices paid by consumers. There's no mechanism for refunding consumers for their losses. And while some political leaders have proposed that maybe we should set up a mechanism like that, I don't think it's actually feasible, and we can talk about why, but I don't think it would work. And second, even for the businesses in question, a lot of the damage was also lost sales or disrupted relationships with investors and suppliers and the like, and there's no compensation for that either. There's no mechanism by which we can compensate a business for a situation where, like, a consumer saw that there is a higher price for this good than there was before, so the consumer bought less of it. And there's no way to provide compensation for that. It's what economists call a deadweight loss. That is, it's just a reduction in the total wealth created in the economy. And so that is why I think it's unfortunate that when we won in the Court of International Trade last year, we got an injunction blocking further collection of these tariffs, but then the appellate court blocked that injunction itself until the litigation was over, and obviously litigation continued for almost a year after that, and so tariffs were collected for almost a year. As a result, we ended up with the $166 billion of illegally collected tariffs, plus all this other economic damage, much of which there's no practical way to repair.
So there are refunds, but it may not be going to the exact people who deserve the money. But again, it's just there's no perfect way to do that. So stepping back from all of this policy and litigation, why should the everyday American care about Trump's tariffs?
For two reasons. One is those tariffs are raising costs and slowing economic growth and increasing prices. I think we've seen over the last several years that everyday Americans care about increasing prices, and also they should care about the fact that these tariffs or others like them, if allowed to stay in place, would reduce economic growth over time and thereby make all of us poorer. They also seriously damage our relations with our allies, which in turn makes it harder to oppose the enemies of liberty and democracy in the world, led by Russia and China. We should be working with our allies and having as much free trade as possible. That makes them and us wealthier, and also makes us a more cohesive Western alliance. So even if people may not care about the legal issues involved, they should care about these practical issues. But even the legal side of it, well, I don't expect the average person to deeply care about the details of non-delegation or major questions or things like that. They should be concerned about excessive concentration of power in the hands of one person. That's bad in and of itself, but it also undermines the rule of law, because the whole idea of the rule of law is that laws governing major parts of the economy and society should be set down in advance by the legislature and the Constitution, and should not be changeable at the whims of one person. And if one person, the president, can impose or lift tariffs anytime he feels like it, that's the opposite of the rule of law, and it creates vast legal uncertainty. Businesses, consumers, investors, and so on, they need to know ahead of time what the rules are going to be, and if those rules can be changed at any time, the president wakes up on the wrong side of his bed and decides to impose impose some new tariffs, as repeatedly happened with IEEPA. For example, he imposed massive tariffs on Brazil, in part because they prosecuted a political ally of his, former President Bolsonaro, who tried to stay in power by launching a coup after he lost an election. He recently said that he might want to impose tariffs on Switzerland because the president of Switzerland said some not nice things to him in a conversation that occurred. Switzerland doesn't actually have a president; they have a plural executive. So I'm not sure exactly who Trump is talking about here. But regardless, Switzerland somehow annoyed him, so he thought maybe he should impose some tariffs on them. We cannot have a system that has both the rule of law and tariffs imposable at the will of the president. Those are incompatible, and also they lead to all sorts of potential abuse. During Trump's first term, he imposed more limited tariffs, and there's evidence that when companies applied for exemptions, ones that donated money to the Republican Party were more likely to get them than those that donated to Democrats. And obviously, if the president has virtually unlimited power to impose tariffs, there's more opportunity for cronyism and favoritism of that type, and no one person should have that kind of power.
The tariffs affect us all, no matter who you are. In some way, you're being impacted. So it really is important to care, even if you agree or disagree, it's impacting you in some way. So that concludes the questions I have for you today. Thank you, Professor Somin, for joining me and breaking down President Trump's tariffs. It was a great conversation, and I really appreciate your insights. If you like this episode, make sure to follow or subscribe to Wahl on Law so you don't miss any future episodes. You can also sign up for our email list at wahlonlaw.com to get notified whenever a new episode drops. Thank you again for listening, and I'll see you next time on Wahl on Law.